Hello, Brian Baer at the Baer Law Firm, here with Carter Wethington, also at the Baer Law Firm, and we're here to talk some law and hopefully have a little bit of fun and educate ourselves and some folks while we're doing it. The first topic that Carter and I wanted to talk about was the legal system in general and what it's there for. We like to think that courts are there to right wrongs, and we as medical malpractice lawyers, we're certainly here to want to fix wrongs that happen to our clients. But in reality, courts aren't designed necessarily to fix wrongs. They're designed to peacefully process disputes.
One of the things with the court system is, a lot of people feel like they might have been wronged in some way, whether it's by a medical provider or another individual, and they think they have some kind of a claim. So, one of the things that can happen is they feel like they need to file a lawsuit, but if you don't have a strong basis to pursue a case and you don't have strong facts in support of your case, then your lawsuit's going to fail. And so one of the things that we like to do, obviously when we're talking with clients, is to set expectations at the beginning and just sort of explain whether it's a valid case or not, and to just explain what the judicial process is and set expectations early, because you never know what's going to happen throughout a lawsuit. You might feel like you have the strongest case in the world, but the people who are going to decide it are obviously going to be 12 strangers of your peers who might have different educational backgrounds, different beliefs, and all kinds of differences than you. And so, one of the things with the judicial process is it's not always fair. You might think you have a great case, but that doesn't mean you're always going to win.
Right. That brings me to a trial I had much earlier in my career, where the client was really surprised and not only disappointed but hurt when the jury didn't find in his favor, and maybe I, as a lawyer, could have done a little better job of setting expectations and how to handle if that happened. Although you want to go into trial feeling confident, pumping up your client, and because you don't ever go into trial thinking that you're gonna lose, right? You are positive and you think the best and you expect the best, but he took it as if the jury thought he was a liar and wasn't telling the truth, and this strong man in his mid-50s broke down after the verdict, and that's not the case. The jury didn't think he was lying. The jury just didn't believe that the wrong that happened to him was the actual cause of his injuries. When we go about proving a case, there's a lot that you have to establish in order to meet the burden of proof for a jury to find in the favor of a plaintiff, and that's particularly true in a medical malpractice case. There's all these different hurdles on facts that we have to prevail on in order to ultimately to get a verdict. And in the case for the client I'm talking about, the jury just didn't believe one component. It had nothing to do with anything that he said, or didn't believe him. They just didn't find that again that the wrong was the actual cause of his injuries. They thought it was due to something else.
Yeah, and I think that goes to one of the things that people might not understand, again, about the fairness of the court system. It does favor defendants. The burden is on the plaintiff to prove that the defense was negligent. And in medical malpractice cases, as you know, it's difficult to do that sometimes because the defense just has to prove that they were reasonable. We have to come with experts and testimony and evidence that's going to show that the defense was unreasonable and that they were negligent. And the burden's on us to do that. And some people don't realize that that's kind of a high bar to meet. And it's why some cases are just hard to bring in general. But it's one of the common misconceptions, I think, is that that everyone starts out on an equal playing field, but in these cases, it's definitely the plaintiff, is starting behind.
Right. I mean, we're fortunate enough that we don't start as far behind as or have a highest burden as beyond a reasonable doubt that you hear about in the criminal case. What our burden is.
Yeah, preponderance of the evidence are more likely than not. It's for football analogy, you got to get across the 50-yard line, and that's what some people like to say. Or the scales of justice, you got to tilt it at least to your side. So it's not as high of a burden, but it is still a burden that we have to meet. And so, sometimes it's difficult to do that in these cases. Even if you feel like the person's been severely injured and it shouldn't have happened, you still have to meet that burden. And so that's, one of the things that I think is important to know at the front so that you set expectations as far as how someone's case might go.
Yeah, and one of the things when you talk about burdens at trial that we try to do in the beginning is educate the jury with respect to those burdens, because it's hard to get the jury to understand. We hear so much beyond a reasonable doubt, and just educating the jury that we still have a burden, but that's not the burden is tough, and I feel like sometimes jurors get confused when they're deliberating I have doubts, and sometimes the burden may be preponderance of the evidence more likely than not, but some jurors will get hung up on the burden. I mean, especially when you're stating or you're accusing, if you will, a respected professional like a doctor or like a surgeon. Is hard. And tell me about some cases where you saw maybe the doctor getting too much of the benefit of the doubt in trials.
I remember a case where if you looked at the facts, it seemed like it was just a completely wrong surgery. The surgeon got there morning of surgery and might have gotten the wrong leg, is essentially what the plaintiff was arguing. But the surgeon was, he was a smart guy. He came from a strong background, strong medical school, strong residency and fellowship, and he was able to come up with a plausible sort of theory as to why he would have made that decision to switch and do the other leg as opposed to the one that was planned for that day. And it actually ended up being, it was not a defense verdict, but it was basically a, we'll give you the medical expenses type verdict. So it was a very good result, and it definitely on the face of it seemed like he got the wrong appendage there. But I think the background and just how well he testified was something that was what the jury held on to.
So in your case, the jury found the doctor negligent, but didn't allow near the amount in damages as the plaintiff asked for, and certainly that sort of everybody that would participate in the trial sort of expected.
Yeah, that's right. I mean, it's sort of like a write-off verdict. They wanted to give the plaintiff something, but it was really to kind of go in the middle. They didn't give them the millions of dollars that were being asked for. It was just the medical expenses, which were not that significant. And so it was sort of just to give them something, but not really to compensate like the plaintiff wanted. And when we're talking about burdens, one of the other things that we deal with is obviously the emergency room issue, where not only do you have the different burdens between the general personal injury cases and criminal cases, you also have a different burden when it comes to emergency room medicine. And so we get a lot of calls about, injuries that occurred in the emergency room. And if it's a true emergency situation, then the doctor gets even more benefit of the doubt, and they get what's called gross negligence standard, meaning you not only have to prove that the doctor was grossly negligent, meaning that they essentially provided no care at all, you have to prove that, and then you also have to show that by clear and convincing evidence. So it's even higher of a burden. So that's one of the other things that people might not know when they're calling about a case. They think about medical malpractice, and you might hear breach of the standard of care or negligence, but you might not be aware of the fact that if it's in the emergency room, that sometimes it's nearly impossible to even bring a case.
Right. It's gross negligence, and then the higher standard, and so the three different evidentiary burdens that we have in our justice system, at least as I understand it, are the lowest, which is preponderance of the evidence, which is sort of more likely than not, and then you have clear and convincing evidence, which is what you need for an emergency room case, and then beyond a reasonable doubt for a criminal case.
Yeah, and it's not really clear what clear and convincing evidence means. It's just somewhere in between preponderance of the evidence and the beyond a reasonable doubt. So more than the 50%, but less than the criminal standard. So somewhere in between, and then also gross negligence. No one really knows for sure what that means, but again, it's just up to the experts to tell the jury what is gross negligence as opposed to just regular negligence.
That's right. I think the doctors would like to define gross negligence as a complete absence of care, whereas even if they did the complete wrong thing, so long as they saw the patient and did something, then that would satisfy. That's not how I see it. How do you see gross negligence?
Well, I mean, I think if you don't do anything, then it's easier to make the case that it's gross negligence. But there's some phrases that say even slight diligence. If the doctor provided used slight diligence in their care, then they meet that. Then they weren't grossly negligent. But I mean, I think you can have situations where they do something that's just so wrong that you can just tell on its face this is more than just negligence. It's a complete just failure in whatever they were trying to do, whether it's operating on the wrong foot, whether it's just causing some severe injury in the emergency room that just not even related to what they should be doing. And
what about grossly misdiagnosing a patient? We're looking at a case along those lines right now, aren't we?
Yeah. I mean, and the misdiagnosis cases are tough. I think it sort of depends on the diagnosis that they fail to make. I mean, and this is where it gets tricky, because if you have a case where they discharge the patient home, they fail to make a diagnosis, send the patient home, then you're arguing, well, the doctor's saying, well, the patient was stable, that's why I sent him home, but then they also want the benefit of this being an emergency situation, and they should be entitled to the gross negligence standard. So you kind of have a catch-22 there, where one side arguing that the patient was an emergent patient, they shouldn't have been discharged home, and that's the plaintiff who's arguing that this was a true emergency. Because in order to get that standard, you have to have it's a bona fide emergency care that's being provided, meaning that the patient came in, they were either going to lose their life, limb, or some severe injury, and so has to qualify as an emergency situation for that standard to apply. But in the case where the patient gets discharged home, the doctor failed to make a stroke diagnosis. They send the patient home, the patient ends up having a massive stroke. Well, it turns out that was an emergency situation when they were in the emergency department, but the doctor didn't treat it as one. So in those cases, it's even trickier, because the judge is probably going to just read both laws, and then the jury just decides whether they want to apply gross negligence versus the standard negligence. And so that's something that is hard to explain to some clients. They might think, and it might look like a clear case, on the outset when you look at it, but then you think about the standard that's going to apply, and not only do doctors usually get a higher bar than most defendants. I mean, if you have a corporation, obviously the jury's not going to care nearly as much as when they see an individual doctor on the other side. And so adding the emergency room issue certainly makes it an even higher bar to get over. But you definitely have those cases where I think it makes it tough for the defense to argue that they should get the emergency standard, because then they have to also say they shouldn't have discharged the patient home. So
right. So we can flip it and turn it back to us, and at least have a plausible argument for the regular negligence standard in medical malpractice cases. Here's a question. You bring up having a corporate defendant, and maybe a hospital would be less sympathetic than a doctor, but what we see in our cases a lot is the doctors who employs them. Do the hospitals employ the doctors?
Well, a lot of times it depends. I mean, it depends where the patient's being treated and what type of doctor you're talking about. If it's just a general hospitalist, most of the time they're going to be employed by the hospital, and therefore the hospital would be vicariously liable. But more often than not, when you have specialist or ER physicians, then it's going to be a completely separate group that contracts with the hospital. And so, one of the challenges that we face at the beginning of investigating a case is just trying to figure out who would even be potential defendants and, who would be liable. And a lot of that sometimes can't even be found out until you've actually filed a lawsuit.
Right.
But, it's a tricky thing you got to navigate because a lot of times you'll have doctors who are multiple groups, and some are hospital or, then you have nursing staff who are generally employed by the hospital. But the answer to that would be it just kind of depends on on the hospital. Some are different, but most I'd say most ER providers are employed by contract groups, ER services who are contracted with the hospital.
And back to litigating a case, and we say litigating, what does that mean? That really means everything after you file a suit up until the point of trial is litigating. And since the design of the courts is to peacefully process this dispute between our client and the defendant, who's most often some sort of medical provider, the folks that we're suing, they typically don't think they did anything wrong, so they're defending the case vigorously, and again, that it's not the courts would like to make the right decision, and it certainly is. Judges and juries, for the overwhelmingly most part, want to be fair. Is my strong sense, but the outcome isn't always fair. The process is designed to reach a peaceful resolution in some form or fashion, so the parties can then ultimately move on. And so what we have to do is we have to vigorously prepare and build the case. And we like to approach that process sort of like a construction project, and it's in various phases. Phase one is just the initial hearing the facts from the client. Does this sound like it potentially could be a case? If it does, then we'll move into phase two, and that's gathering the initial medical records around the treatment that we think could be negligent, which could be below the standard of care. And then if in looking at those medical records, it looks like it, but we're not doctors. We're not, and what we say about the facts, ultimately doesn't matter. It's not evidence. We can make all kinds of arguments, but it's not evidence. We actually have to have actual evidence from other medical providers in the exact specialty that say it was malpractice to treat our client this way. So phase three would be sending those medical records and films, et cetera, to experts or providers who share the same specialty, and seeing what they think. And then it moves on to phase four and ultimate phases, and we try to then build the case, and we like to have the project as built as much as possible before filing suit. We want to control everything in our power that we can control, because there's so much out there that we can't control. And then phase 5 is the actual filing of the lawsuit. From there, the case can go in any number of permutations. In a small number of cases, we'll file suit. And Carter, talk about a case that we've had where we filed suit. We thought it was going to be a very lengthy process, but we actually got a surprise call from defense counsel and wanted to see if we could resolve.
Yeah, I mean, it happens where we'll file a case. You think it's going to, I mean, because as you know, sometimes these cases can take years, especially medical malpractice cases. I mean, on average, it can take 2 to 3 years to get to a trial. So it's not often that you file a complaint and then you hear from the defense right away, but we've had a few cases where we had strong facts and good clients, and we got a call from the defense attorneys almost immediately to set up a mediation or try to resolve the case. And obviously, if we can do that and it makes sense at the time, then we'll do everything we can to try to do that.
And talk about, because I thought that complaint, or the lawsuit which you drafted, I thought it was really well done to at least give the case the best possibility of that happening, and talk about a little bit about what you did with that complaint to try to put it in that position.
Yeah, I think one of the things that, as you were talking about, is just when we're investigating a case to make sure that we pull you got to go through all the records. I mean, it takes a long time, but there's always going to be some important things hidden in there, whether it's in the nursing flow sheets or in the labs, things like that. And so you got to go through, and then if you put together a strong, detailed complaint, some people will just put general facts and here's the negligence and file a lawsuit. But I think if you do a detailed complaint and really lay it out so that they can see where the negligence was and where their documentation's lacking, then it certainly helps, and it might pique their interest in trying to resolve the case early. And then obviously if they don't want to do that, and we've got to pursue the lawsuit going to the courts in general, and how they're not really designed to resolve these cases. I mean, they might help us move the case along, and they're really the referee who's deciding whether things are appropriate or not appropriate, but it's not always going to seem fair. I mean, in these cases, when it comes to what the court's going to allow at trials, we might have some evidence that we think would be super helpful if the jury knew about it, prior lawsuits or things that
or what about the hospital's investigation afterward, and we can't even learn any about it. We can't even learn if the hospital investigated the matter afterward, can we?
No, I mean, it's one of the things that sort of goes against the plaintiffs, especially in medical malpractice cases. After they passed tort reform, they came up with a lot of protections for hospitals to be able to investigate claims, and like you said, the peer review process is one of the ways they do that, where they talk about what happened, they'll gather information, talk to the witnesses, and they might know exactly what went wrong, but they don't have to tell you that. And so that information is not going to be discoverable. It's not going to be allowed at trial, even if you know about it. And so you might know information that you can't use to try to win your case. And so in that way, people might think that they have all this, background information. Oh, this doctor had 5 lawsuits for something very similar beforehand, but it might not be allowed in at trial, and it might not be something that the jury's ever going to hear about. And so while you might think you have, the smoking gun evidence in your back pocket, it's not always going to be allowed by the court. And so
truth and candor matter, and we always tell our clients, tell the truth. And from the outset, we try really hard to make sure we gather all the information from our clients that the other side asks for. Early in my career, I won a case that I had no business winning. The facts were just really not on the client's side, and even the judge, when we went up and talked to the judge before trial about what the trial was about, she gave this weird look like, why are you thinking that you have a chance of winning this trial? But what made the difference in that case was that the defendant failed to produce documents that the jury expected them to have, and the defendant couldn't produce those documents, and the jury made him pay for it. They found for my client, because she produced everything that she had that was relevant to the case. She told the truth. There were some really bad facts. She didn't hide behind those facts. She said it the way it was, and the defendant looked like they were hiding the ball. So we are open and honest with the jury. And that's the only way you're going to prevail in a plaintiff's medical malpractice case. Is you've got to address the elephant in the room. You've got to be open with the jury about the facts that are good for your case and the facts that are bad for your case. And where a lot of defendants make their mistakes that allow us to win is when they're hiding the ball on stuff.
I think that's one of the important things we always try to do during cases is find if they are trying to hide the ball somewhere, and being thorough in discovery and making sure that we, check off every single thing we can think of, prior to getting to trial. And that's one of the ways that we are prepared to handle these situations at trial. And I think that goes to just starting from the investigation phase and through the discovery process, just being super thorough and making sure that we do our best we can to discover any potential missing documents, things like that that'll help us, well, one, learn all the facts, and two, maybe help us on an issue that they're hiding, or, something that doesn't look good for them might be discovered later on. They're not just going to produce those types of things a lot of the time without you doing some investigation work. So.
Right.